Good evening to the participants of the JCJ Andhra Pradesh 2023, which is going to be held on 7th January 2023 if it is not postponed. Anyone can unmute and read what I posted on the screen? I said anyone can unmute and read what I posted on the screen. Participants, are you hearing me? Anyone can unmute and read what I posted on the screen. Here.
Specific Relief Act, Possession of Property 5 to 8, Specific Performance of Contracts 9 to 25, Rectification 26, Rescission 27 to 30, Cancellation 31 to 33, Declaratory Decree 34 to 35, Injunction 36 to 42.
Yes. And next, I don't think that you could able to read it. That is the Specific Relief Act of 1963. The act contains how many, the three parts and how many chapters? That is there in the next one. And when you see the below the cursor, I am showing remedies under the Specific Relief Act 1963. Then the bullets are given recovery of the position of the mobile property, and second bullet recovery position of the mobile property, and third bullet is specific performance of the contract, and the fourth bullet is rectification of the contract, and fifth bullet is rescission of the contract, and the next is cancellation for an instrument, the next is the declaratory decrees, and the last is injunctions. So these are the things which are there, and this is for both of you, and hence that I posted welcome to the aspirants of the APJCJ 2023 ST and the All India Bar Examination 2023, as it is a both in exams with the common act it is. So that's why that I made the invitation to them, and without the wasting the time, let I go to the our studies concern, and here I put it already. Yes, sir. Be ready. The Specific Relief Act 1963, multiple choice question, 24th December 2022, and start from 9 p.m. to 9:50 p.m. India time, and the Tanzania time is 6:30 to 7:20 p.m. Yes, first question is, what is the exact or the correct or the accurate style of writing SRA? A. The Specific Relief Act, 1963 full stop. B. The Specific Relief Act of 1963. C. The Specific Relief Act 1963. D. The Specific Relief Act, of 1963. Which is the exact way we could see in the Bear Act. Shoot. Participants, are you there?
Yes, sir.
Then give the shoot the answer. Sir, we are checking the smartphone, sir, how it looks like, the Bear Act.
Option C, sir, the Specific Relief Act 1963.
You have taken the so much time. By looking it, you have to give the answer. Just by looking it. See the Specific Relief Act, 1963. It is given over there. So time is very important factor. So answer is the C is the right answer. Okay, now next question. 1A, I made it later. The Specific Relief Act 1963 is an act of the Parliament of India that provides the remedy for the persons whose civil or dash have been violated. Option A, criminal rights. Option B, human rights. Option C, general rights. Option D, contractual rights.
Option A, sir, criminal rights.
WRONG.
Option D, contractual rights, sir.
It is the option D is the contractual right is the right answer. So that is the right answer. Answer D, it is the contractual rights. Okay, next question. Anyone can unmute and read? Second question. Unmute and
The
read.
Specific Relief Act of 1963 replaced an earlier act of dash. Option A 1875, option B 1876, option C 1877, option D 1878.
You have to shoot it immediately. Not that much time. Before the host reads or the participant reads out the D option, you should be in a position to shoot it. Because already I told you to read and come to the class. Oh, you are taking so much time. The red option
Option
is,
C, 1877.
it's the C, right option is C, that is the 1877. It is the old act, it is replaced by the 1963. Third question. The equitable remedy of injunction bears such a marked resemblance to certain forms of the interdicts which were granted by the dash under the dash. A. Roman law and praetors. B. Praetors and Roman law. C. Predators and Roman law. D. Roman law and predators. Check again. The equitable remedy of injunction bears such a marked resemblance to certain forms of the interdicts which are granted by the dash under the dash. A. Roman law and praetors. B. Praetors and Roman law. C. Predators and Roman law. And D. Roman law and predators. Participants, those who don't want to speak, I could hear your house dialects. Mute. When you are speaking at the time, you have to mute it. Dheeraj, off your video. Dheeraj, off your video. When you speak at the time, you unmute it. When you don't want to speak, mute it, because I could hear your dialogues, inside dialogues. Why you are taking so much time? Sir, this we did not see at any place. Yes, I told you no, you did not see that what I prepared it. Answer is B. It is a praetors and Roman law. I will show you here. Let me close this one. The equitable remedy of injunction bears such a marked resemblance to certain forms of the interdicts which are granted with the praetors under the Roman law. It is taken. What is meant by praetors? The praetor means is a singular, plural is praetors or praetores. In ancient Rome, judicial officers who had broad authority in cases of equity was responsible for the production of the public games and in the absence of the consuls exercised extensive authority in the government. It is a judicial officers at the time, and that is called praetors. And the predators means an animal that naturally preys on the wolves are the major predators of rodents. I don't know whether you see the movie Predator number 1, number 2, number 3. Arnold Schwarzenegger, 7 times Mr. Universe in the world. Of course, he contested in the election also in the USA. Did you get my point here? What is the right answer for the third question?
Option B, sir.
Option B. It's a praetors and Roman law. So now next question. The fourth question. In which chapter dash rectification of instruments, less number of the sections, or only one section is there? A. Chapter 1, B. Chapter 2, C. Chapter 3, D. Chapter 4.
Option C, chapter 3.
Yes, it is a chapter 3, only one section is there. Is it clear?
Section
So
26.
what is the section?
Section 26.
It is a section 26 is the only one section in the chapter 3 of the Specific Relief Act of 1963. Shall I proceed? Say yes.
Yes, sir.
Yes,
Good.
sir.
The sixth question. Anyone can unmute and read the sixth question loudly. Quick.
Specific performance shall be enforced, replaced in the dash of the court.
Option A, mandatory. Read.
Option B, direction. Option C, discipline. Option D, discretion.
Option A, mandatory, sir.
WRONG. In the
Discretion.
amendment,
Option D.
shall be enforced
Option
is
D,
replaced.
Option D, discretion.
Option D is the right answer. Sridevi gave the right answer, J. It is a discretion now. Earlier it shall be enforced. But now, after the Amendment Act, later on, shall be enforced is replaced by the discretionary. That is a discretionary power of the court. That is the right answer for the sixth question. Then seventh question. How many sections are repealed in the Specific Relief Act 1963? Option A, 1. Option B, 2. Option C, 3. Option D, 4. Sir, we did not expect such a question also to be asked, sir. I told you, I want to shoot in 3 dimensions. X-axis,
Option A.
Y-axis and
Option.
Option B.
Option A.
Option B, sir.
Option A.
WRONG, both of them.
Option C, sir.
WRONG. What is the right answer?
Option D.
Option D, sir.
Option D.
B, 2. TWO2 sections. I told you how many axes are there? X-axis, Y-axis and... Sir, we are BSc now, sir. We are the BJC, sir. We are not a mathematics student, sir. 3 dimension. X-axis, Y-axis and Z-axis. So I can shoot from any axis. Only 2 sections are there which are repealed. Now, what are they? What are those sections which are repealed in the SRA 1963? A, 4041, B, 4142, C, 4243, D, 4344.
Option C, 42 and 43.
WRONG.
Option D, 43 and 44, sir.
Right, RIGHT, right. It is a D, 43 and 44. What is this symbol say in Latin terminology? I already told you.
And
Equivalent is and. I already discussed this many times. Sir, we have forgotten, sir. Ampersand, AMPERSAND, equivalent is and. Is it clear?
Yes, sir.
Yes. Is it clear?
Yes, sir.
Repeat.
Yes, sir.
Repeat. Repeat the spelling. AMPERSAND, ampersand. Okay. Section 43 and 44 represented by the Repealing and Amending Act of 1974. That is the, even they can ask what is the Amending Act number 56 of 1974. And it is given in the section 2 of the first schedule with the effect from the 20 December 1974. Supplementary question. What is the act number of this Specific Relief Act of the 1963? Supplementary question. Act number of the Specific Relief Act.
47.
47 is the simple question. That's why I did not ask it. Read ninth question.
The Specific Relief Act of 1963 is considered to be one of the branches of the option A, the Criminal Procedure Code, option B, the Civil Procedure Code, option C, Indian Contracts Act, option D, Law of Evidence. Option B, Civil Procedure Code.
Civil Procedure
Option
Code,
B,
sir.
sir.
WRONG.
Option C, Indian Contract Act.
RIGST is a part of the Indian Contract Act. Supplementary question. Indian Succession Act 1925 appeared in the Bear Act. In which section? Sir, we don't know, sir, where it is appeared over there. If you see, happen to see section 2 here, settlement. Did you see the settlement? Indian Succession Act 1925. They may ask like that also a question. Indian Succession Act, first time, where, in which section it is written? Then you have to say, sir, definition 2, class B. Section 2, class B, it is mentioned. Supplementary question. Do they ask? Yes, they can ask in that way also. That's why I made a model. Okay, next. 10th question. Anyone can unmute and read 10th question?
The amendment modifies by substituting the words the specific performance of any contract may, in the discretion of the court, be enforced with specific performance of a contract shall be enforced by the court. Option A, Section 8, option B, Section 9, option C, Section 10, option D, Section 11.
Option C, Section 10, sir.
Right. It is option C, section 10. 1974 amendment, they modified it, the section 10, and mandatory is removed and discretionary of the court is put it over there. Okay, 11th question. Which statement or option is correct? Here I give the 4. Section 6 of the Act permitted the following person to file a suit for recovery of possession of immobile property. 2. A person put out a possession or disposed person. And 3. Any person claiming through such a disposed person. 4. The amendment now additionally permits the person through whom the disposed got the possession of the mobile property to file a suit for recovery. Option A, 1 plus 2 plus 4. Option B, 1 plus 2 plus 3. Option C, 2 plus 3 plus 4. Option D, 1 plus 3 plus 4. Did you understand the question first? Which statement or option is correct? Among the 1, 2, 3, 4 statement I made, then option I made A, B, C, D just before I read. Shoot the right one. The correct proposition and correct option.
Option D, 1 plus 3 plus 4.
WRONG.
Option B, sir. 1 plus 2 plus 3.
Option B is the correct answer. 1 plus 2 plus 3. What is wrong in the 4? Can anyone tell me?
Sir, option C, 2, 3, and 4.
Yes, you are right. Just now I told you. No, it is 1, 2. B, 1 plus 2 plus 3. Okay, let us check it. Who is right? Then what is wrong in the 4 and what is wrong in the 1? Here I have given. Feedback I have given. I think the 2 feedbacks are there. No, 1 feedback is there. The amendment now additionally permits a person through whom the disposed got the position of, I wrote immobile property here. Actually, it is a mobile property. Is it? It is a immobile property, not a mobile property. To file a suit for the recovery. So, 4th one, there is a mistake. So, when there is a 4th one mistake, what is the correct answer?
Option B, sir.
1, 2, and
Option
3,
B
sir.
is the
Option
correct
B.
answer. 1 plus 2 plus 3 is the correct answer. Is it clear? See, here I put
Yes,
immobile
sir.
property.
Yes.
And here I put the mobile property. It is refers to the only immobile property, section 6. Is it clear?
Yes, sir.
Yes, read the 12th question. Quick.
Whether any appeal is allowed against the order of decree passed in any suit instituted under Section 6 of the Specific Relief Act 1963. Option A, yes, an appeal can be allowed. Option B, no appeal shall lie from any order or decree passed in any suit instituted under this section, nor shall any review of any such order or decree be allowed. Option C, appeal can be allowed if permitted by the court who has given the order or decree. Option D, appeal is allowed or not allowed depends upon the nature of the case.
Option B, sir.
Option B is the right answer. No appeal shall lie from any order or decree passed in any suit instituted under this section, nor shall any review of any such order or decree be allowed. What is the wrong here in 12th question? Can anybody tell me? What is, I committed a mistake. Quick. Which I highlighted. I committed a mistake. Can you tell me what is the mistake?
Not allowed. Not allowed. Not allowed. No
I
appeal.
said here,
Whether no-
here. I made a mistake, I told. I highlighted also. I wrote small a. It should not be small a. It is a capital A. I highlighted but you are reading the A. But anyway, 13th question. Notwithstanding anything to the contrary contained in any person suing for the specific performance of a contract for the transfer of the immobile property may, in an appropriate case, ask for the possession or partition and separate possession of the property, in addition to such performance or any other relief to which he may be entitled, including the refund of any earnest money or deposit paid or made by him, in case his claim for the specific performance refused. Number A. The Code of Criminal Procedure 1973. B. The Specific Relief Act of 1963. C. The Code of Civil Procedure 1908. And D. The Transfer of Property Act 1882.
Option C, the Code of Civil Procedures, 1908.
It is the Code of the Civil Procedure is the right answer. Is it clear? Say yes.
Yes, sir.
Okay, 14th question. What recourse is available to a person if he is dispossessed with his consent of immobile property otherwise than in due course of law? I made A, B, D options. He may, by criminal suit, recover the possession thereof, notwithstanding any other title that may be set up in such a suit. B. He may, by mortgage suit, recover the possession thereof, notwithstanding any other title that may be set up in such a suit. C. He may, by money suit, recover the possession thereof, notwithstanding any other title that may be set up in such a suit. D. He or any person through whom he has been possession on, or any person claiming through him may, or by suit, recover the possession thereof, notwithstanding any other title that may be set up in such suit.
Sir, option D.
You are right. It is option D is the right answer. See, I made you to make the different angles, x-axis, y-axis, z-axis. Even though you don't know the answer, but you can shoot the right answer because you are employing my equations. And hence, you can shoot it. That is the reason I told you not to take any bare axe in your hand. Go with your full-fledged, filled brain. I repeat, don't take any bare act in your hand. You will become a parasite. 15th question. Which statement is correct or exact or appropriate statement among the four? A, B, C, D. A. The general rule is that sanction of an injunction is a matter of discretion of the court and it cannot be claimed as a right. B. The general rule is that issue of an injunction is a matter of discretion of the court and it cannot be claimed as a right. C. The general rule is that the order of an injunction is a matter of discretion of the court and it cannot be claimed as a right. D. The general rule is that the grant of an injunction is a matter of discretion of the court and it cannot be claimed as a right. Which is the correct and exact and appropriate statement?
Option D, sir.
Repeat.
Option D, sir.
Option D is the right answer. There is no is that order of an injunction. There is no the issue of an injunction. There is no the sanction of injunction. But what is there? This is highlighted here. See. The grant of injunction. What is highlighted? The grant of injunction. That is very important factor. Yes, anyone can unmute and read. 16th question. Quick.
However, has to be exercised in a judicious
Sai Teja, read loudly.
However, the discretion has to be exercised in a judicious manner and in accordance with the provisions relating to the grant of injunctions contained in the option A, Constitution of India, option B, Criminal Procedure Code, option C, Civil Procedure Code, option D, Specific Relief Act 1963.
Option C, Civil Procedure Code, sir.
WRONG.
Option D,
Specific Relief Act.
Option D, the Specific Relief Act of 1963. Sai Teja, you did not write dash or blank in the dash. That is the way of saying. Okay, now, 17th question. When an injunction cannot be granted, number 1, to restrain any person from instituting or prosecuting any proceeding in a criminal matter. 2, to prevent the breach of a contract, the performance of which would be specifically enforced. 3, to restrain any person from applying to any legislative body. Option A, 1. Option B, 1 plus 2. Option C, 2. Option D, 2 plus 3. I show here. When an injunction cannot be granted, now look at it. Yes? Choose the option here. Okay, I will drag it here. Choose the option. Shoot.
Option D, 2 plus 3, sir.
If you say option D, WRONG.
Option 2.
You should not
Show
speak like that. You have to give the answer full. I say shoot. Option B, 1 plus 2 is the right answer. Option B, 1 plus 2 is the right answer. Feedback. To prevent the breach of a contract, the performance which would not be, I removed not from here. I think when such a thing would be there, to prevent the breach of contract of a person which would not be, to prevent the breach of contract of a person who would not be removed. That means there should be not. So the option is 2, not 2 plus 3. I believe again that to prevent the breach of a contract, the performance which not be anyway subject to the correction. Something is I missed here. A correcting factor, something I missed. So anyway, that I will make you check it, then I will inform you later once the class is over regarding the 17th question. Take the screenshot. Take the screenshot, I will explain you later. Okay? Now, 18th question. It is held by the court that when in a case it is observed that the plaintiff itself did not perform his portion in the contract or neither does he wants to perform, so the decision regarding the specific performance act will be issued under this favor. A. B. Rajamani versus Azhar Sultan and others. B. K. Raju versus P. Ramalingam, deceased, within parenthesis. C. NP Tiruganan versus R.J. Mohan Rao. D. Mrs. Anant Raj Agency Private Limited versus Mrs. Shringar Hotel Private Limited. In which case law it is decided?
Option D, sir.
Wrong.
Option B, sir.
Wrong.
Option A, sir.
C.
Option A also wrong.
Option C, sir.
NP Tiruganan versus Dr. R.J. Mohan Rao, it is decided in that case law. 19th case law. The amendment introduced a new provision, i.e. it este means that is dash, which will empower and enable the court to engage one or more technical expert to assist on any specific issue involved in any suit. The expert may also be called upon the providing the evidence, including the production of relevant documents related to the issue. Here the dash is section 14, B option section 14A, capital A, C option section 14, capital AA, and D option section 14, capital A and capital B.
Option B.
Section 14A, sir. Capital A.
The right answer is option B, section 14, capital A is the right answer. Not the C, not the D. Is it clear?
Yes, sir.
Good.
Yes, sir.
Please find the 20th question. Please find one which is mismatch among the following. I say mismatch. Please find out one which is mismatch among the following. A. Section 2 of the Specific Relief Act 1960 deals with some important definitions. B. Section 2A deals with the obligation which are duties imposed on a person by the law or legal body. C. Section 2B deals with the settlement, which means the delivery of the movable and immovable property to their successive interest then it is agreed to be disposed of. And D. Section 2C deals with the word trustee, which means the person holding trust in property. Which is the mismatch here among the ABCD? Either A is mismatched, B is mismatched, C is mismatched, or D is mismatched. Even though it is wrong, shoot.
Sir, put the options together, sir.
Yes.
Option A, sir.
Option A, sir.
Option D, sir.
Option D, sir. Option D.
Section 2 of the Specific Relief Act 1963 deals with some important definitions which are as follows. The same section 2, there is no change at all. If you see the section 2A deals with the obligations. Yes, 2A deals with the obligations which are duties imposed on a person by the law or the legal body. Yes, it is also no change. But 2B and 2C, you check it. 2B deals with the settlement, that means delivery of the movable or immobile property, 2B. And here 2B deals with the settlement with the means delivery of the movable and immobile property. Then the last one, 2D deals with the word trustee. Here 2C deals with the trustee. Are you following me? Which one is mismatched?
2D, sir.
2D is mismatched. Here I said 2C, I made it. but 2D is a mismatched here. So instead of C and D, I made it. So mismatched is 2C there in the answer is. Actually it should be a 2D, but I made 2C. Is it clear? See, sometimes they will ask the mismatched also. So all other different which are not been explained here in the same, of course, this is a different issue. So in 21st question, section 5 explains that remedies available to a person when he is disposed from his property. If a person has been removed through the line of possession or wants to recover the lawful is his property, then that person can do so through the recovery procedures provided by the dash, and in which the person will prove that the title belongs to him. Option A, law of contract. Option B, law of evidence. Option C, specific relief act. Option D, code of civil procedure. Code.
Option B, Code of Civil Procedure.
Code of Civil
Option
Procedure.
D, sir.
It is the D is the right answer. Code of civil procedure. Now 22nd question. Anyone can unmute and read.
The court in this case held that when a contract is valid, no doubt of it being cancelled arises, and when it is void ab initio, meaning no existence in the law from the starting, then no option of cancelling it arises, as it is not present in the eyes of law. When a contract has no existence, no action is enforced on it, decided in the case of option A, Prem Singh versus Birbal. Dash.
A.
Option A, Prem Singh versus Birbal. Option B, Balakishore Prasad and others versus Chowdo Devi and others. Option C, R. Sarala versus Chandrasekhar. Option D, against the judgment and decree versus suit.
Option C, sir.
WRONG. The right answer is option A, Prem Singh versus Birbal. 23rd question. There are certain essential requirements for the fulfillment of recovery under this section that are as follows. Which statement is the correct option? Number 1. The person suing for a disposition must be in possession of the property. 2. The person must be possessed the property. 3. Such divest from the property must be unlawfully done or must be carried out against the nature of law. 4. The disposition must be with the consent of the person suing. Options. A. 1 plus 2. B. 1 plus 3. C. 2 plus 3. D. 2 plus 1. Which one is the appropriate answer?
Option A, 1 plus 2, sir.
Repeat.
Option A, 1 plus 2, sir.
WRONG. Second option.
Option B, sir, 1 plus 3.
Option B is 1 plus 3. The reason is, if you happen to see the 2, the person must be dispossessed from the property. I wrote possessed from the property. He should be first dispossessed from the property. Means 2 is wrong. Then the 4th, the disposition must be without the consent of the person suing. But here, the disposition must be with the consent of suing. Here, without the consent. Hence, 2, 4 is wrong. Then what is the right? 1 plus 3 is right. When 2 and 4 is wrong, what is right?
Option B, 1 plus 3.
Yeah, why you are not giving answer? 24th question. Anyone can unmute and read? Loudly.
Essentials of section 7 are as follows. 1. There must be a presence of property that is capable of being delivered or disposed of. Second one, the person suing must have possession of the property in question. Third, there may be an existence of a special or temporary right on the property. Option A 1 plus 2, option B 1 plus 3, option C 2 plus 3, option D 1 plus 2 plus 3.
Sir, option D, 1 plus 2 plus 3.
WRONG.
Option A 1 plus 2.
WRONG. I used my intelligentsia. When I was preparing it,
Option B.
I used my
Option B,
entire
1 plus 3.
intelligentsia.
Option C 2 plus 3, sir.
Tell me
1
why.
plus.
Option C, why 2 plus 3 is right. What is wrong in number 1? What is wrong in number 1? I said there must be a presence of what property? Movable property.
Movable property.
That I removed the movable here. And hence, I told you, I used my intelligentsia. And I framed it. So, you may be confused. So, in that way also they may ask a question. So, the 24th question, right answer is 2 plus 3 because there should be a movable property should be here. But I removed the movable. But here I put it, this is the right answer. Movable should be there. Okay, 25th question. Let me see how your intelligentsia work here. Injunctions. Injunctions are a specific order under which a party must abstain from performing any act. Injunction under the Specific Relief Act 1963 may be divided into different types of, namely, number 1, temporary, number 2, perpetual, number 3, prohibitory, number 4, mandatory. Options: A 1 plus 2, B 2 plus 3, C 1 plus 2 plus 4, D 1 plus 2 plus 3 plus 4. Shoot. Under the Specific Relief Act injunctions.
Option C 1 plus 2 plus 4.
What is wrong in the 3?
Prohibitory.
There is no prohibitory injunction. There is no prohibitory injunction. And yes, but injunctions are how many types? I don't know whether you know this. Mareva injunction. Popularly, Mareva injunction is an interlocutory ad personal injunction which restrains the respondent or a judgment debtor or the party to whom it is granted from disposing of its assets otherwise than the usual course of business beyond the jurisdiction of the concerned court as to render or evade it. A Mareva injunction also we can call freezing injunction. Of course, in the master's level you study it. 26th question. Section 37, subsection 1 of the dash deals with the temporary injunction which are such are to continue until a specified time or until further orders of the court, and they may be granted at any stage of the suit or proceedings are regulated by the dash. Number A, Specific Relief Act 1963 and a Code of Civil Procedure 1908. B, Code of Civil Procedure 1908 and a Specific Relief Act. There are 2 dashes are there. C, Specific Relief Act 1963 and Section 94-95 Order 39 of the Civil Procedure Code 1908. D, Section 94-95 and Order 39 of the Civil Procedure Code 1908 and Specific Relief Act of 1963. Now you fill which is the appropriate 2 blanks among the A, B, C, D. Shoot.
Option C.
Run.
Option A. Option B, sir.
Run.
Option B.
Option A, sir.
Option A is the correct answer. Section 37, subsection 1 of the Specific Relief Act, and next the regulated by the Code of Civil Procedure 1908. Other thing, I manufactured, I concocted, I designed, I falsely made. Is it clear?
Yes, sir.
27th question. A judicial process whereby a party is ordered to refrain from doing or to do particular act or thing according to dash. A. Black's Dictionary. B. Oxford Dictionary. C. Hallsbury's Laws. D. Orient Longman Dictionary.
Option A, Black's Dictionary.
Wrong.
Option C, sir.
Option C is the right answer. Hallsbury's Laws. I want to keep another also. Privy Council definition. But I don't want to confuse too much. So I removed the Privy Council and put the Orient Longman Dictionary to make you to read. I know that you definitely shoots the Black's Dictionary because many definitions are taken in the law from the Black's Dictionary. So Oxford Dictionary meaning the word injunction is a judicial warning or a judicial order in restraining a person from an action or compelling a person to carry out a certain act. 28th question. Read anyone?
An injunction is an dash and as such attracts the application of the maxim that he who seeks equity must do equity. Option A, legal remedy. Option B, ethical remedy. Option C, constitutional remedy. Option D, equitable remedy. Option A,
D,
legal remedy.
Right.
Option A, sir.
Second option.
Option D,
Option D.
Option D. Option D. Equitable remedy. Option D is the equitable remedy. A person who goes to the court goes with the clean hands. So equitable remedy is the right answer. 29th question. Injunction mentioned from dash under the specific remedy act. Not remedy act. It is a specific relief act 1963. A. Section 35 to 44. B. Section 36 to 45. C. Section 36 to 44. D. Section 35 to 44.
option C, 36 to 44.
Yes. Option C is the right answer. That is the section 36 to 44 is the right answer. Okay, now let me check your mind. The object of granting the permanent injunctions include find the odd man out. A. Preventing continuous injury and violation of the legal right to plaintiff. B. Curtailing the addition of the judicial proceeding to the continuous violation. C. Providing equitable and complete relief for the plaintiff where damages don't solely suffice. D. Preventing the breach of an express or implied legal obligation existing in favor of the defendant. Which is the odd man out for the permanent injunction? Shoot.
Option B, option B,
Why?
curtailing addition of judicial proceedings due to continuous violation.
Then what should be there? No doubt you are right.
Multiplicity
There is no
of judicial
addition.
proceedings.
Curtailing the multiplicity of the judicial proceeding. I made, instead of multiplicity, I say addition. No doubt you are right, but you should also know what is the right word. Anyway, that because my logic is working, my equation is working, my axis is working, my sphere is working, my 3-dimension is working. Okay, now 31st question, read.
Section 27 deals with the dash of the contract in law. Option A, revocation. Option B, review. Option C, rescission. Option D, remission.
Option C, rescission, sir.
Yes, it is a rescission. Option C is the right answer. Is it clear?
Yes.
Say yes. Yes. Next, 32A. Read. No, I will read it because it's a difficult one. 32 question. Rescission means withdrawing of the contract or in simpler terms, cancellation of the contract. It brings the party in a situation as if the contract did not happen, i.e. it has stay that is dash meaning in its original state. A. Qua status ante. B. Ante status quo. C. Status quo ante. D. Qua ante status. Shoot. A,
Option
B,
C,
or C,
sir.
or D.
Option C, sir.
Option C is the right answer. See, that means my equation is working. You don't know how you pronounce status quo ate. N is not the status quo ate. So that is the way of pronunciation. So anyway, feedback is the previously existing state of affairs. That is the reversion to the status quo ante. That is the meaning of it. 33rd question. A contract may be cancelled through the rescission in cases dash where the plaintiff has himself given a consent to the contract. 2. Where the third party has gained the interest in the contract where their right came into existence. Question. C. B. Where only a portion of the contract is to be concealed, but it is not such a position that the faulty portion cannot get separated from the contract. Option A 1 plus 2, option B 1 plus 2, option C 2 plus 3, option D 1 plus 2 plus 3. See, I drag it down here so that you could know it. A contract may be cancelled through the rescission in the cases. Here the condition given 1, 2, 3 and shoot the right answer.
Sir, 2 plus 3.
Option
C. Option
1.
C.
WRONG.
Option A 1 plus 2.
WRONG.
Option D, 1 plus 2 plus 3, sir.
Right. It is a.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We live in a world